On the agenda is the Homeless Services Reform Amendment Act of 2017, Bill 22-293. Councilmember Nadeau.
Thank you, Mr. Chairman. I'd like to refer to my remarks from the Committee of the Whole regarding the underlying measure. At this time, I will be moving an amendment to B 22-293 that makes changes to several sections in the bill as related to definitions, redetermining eligibility, and program exits. This amendment is predominantly clarifying in nature and better honors the established intent of the bill. First, the amendment makes clear that applicants on the verge of eviction should be considered at risk of homelessness. Under the committee print, applicants for assistance may find it difficult to prove one of the possible conditions to establish being at risk of homelessness, which includes written notification that their right to occupy their current housing or living situation would be terminated within 21 days of the date of application for crisis intervention assistance. Not all landlords, however, supply such written notification. Thus, under the amended language, an applicant need only demonstrate that they were somehow notified or can otherwise document such termination, even if not in formal written format, i.e. notification or documentation of past due rent. Second, the amendment removes any ambiguity from the definition of homeless as related to the eligibility of an individual or family who has lost their primary nighttime residence the same day as the application for services. This was always the documented intent of the legislation as well as the federal regulations, after which this provision of the bill was mirrored. By amending the language in this way, however, it adds clarity and removes any future interpretation that may attempt to exclude individuals and families who have yet to spend a night on the streets. Third, the amendment clarifies the intent of ensuring that a client whose program eligibility is being redetermined has a right to maintain uninterrupted service during the transition. The committee print included a cross-reference to transfers, but that is not a process that is necessarily applicable to eligibility redetermination, as those are two separate and distinct processes as conducted by the Department of Human Services. Finally, the amendment better aligns program exits with other termination processes. The committee print altered the bill as introduced to reflect the notion that clients being exited from a housing program should have the same due process rights as clients facing other forms of service denial. The amendment would apply across the board. The notice requirements and appeal rights applicable to other types of service denials to clients facing program exits. And with that, I move this amendment.
Thank you, Councilmember Nadeau. So we have this amendment before us. If there's no objection, it will be accepted. Hearing no objection, it is accepted.
Thank you, Mr. Chairman.
I'm going to move an amendment. The amendment that's being circulated, the purpose of it is to ensure that those who have access to safe housing are not considered homeless for the purpose of accessing emergency shelter. The amendment also ensures that there are appropriate protections for those who are fleeing domestic violence, sexual assault, and human trafficking. To say a little bit more about this amendment, if the mayor determines that an individual has or family has safe housing, then the mayor may presume that the individual or family is not eligible for shelter. However, if the individual or family provides credible evidence, and that's the standard, credible evidence that it is impossible to return to such housing, then that overcomes the determination. The presumption does not apply to individuals or families seeking shelter for reasons of domestic violence, sexual assault, or human trafficking. In addition, the amendment makes clear that the access to shelter does not affect an individual's or family's eligibility for crisis intervention services, including family mediation, conflict resolution, or other family stabilization services. And I emphasize other family stabilization services. So this is my amendment. Councilmember Nadeau.
Mr. Chairman, I'd like to accept that amendment as friendly.
Mr. Chairman, I'd like to object.
I was going to say if there's no objection, but Mr. Grasso, you're objecting?
Yes.
All right. Is
I'd
there
like to speak
discussion?
to it. Yes, please. Thank you, Mr. Chairman, and I wanted to just object so that I could vote against this amendment. This amendment actually would add language to the Homeless Services Reform Amendment Act of 2017 to require an individual or family to prove that they do not own or lease safe housing. Members of the Human Services Committee agreed to remove this language because it would create yet another barrier for people to receive the services they so desperately need. So I'm actually deeply disappointed to learn that there's an effort to add this back into the legislation. And Mr. Chairman, I also have a question. Would the credible evidence standard include a credible oral statement? It's my understanding that the Federal Hearth Act requires that an oral statement from an individual or family may help establish credible evidence of a person's homeless status. Without this requirement, I believe that this amendment is even more harmful. So would the credible evidence standard include a credible oral statement?
The standard would permit a oral statement. If it's credible, then that would meet the burden.
So would it permit?
Evidence is evidence, however it's presented. And then
No,
the
Mr.
question
Chairman,
is
I think
whether
it has
it's
to be.
credible.
Anyway, okay, I'm curious
If
if
your
it does.
question is whether oral evidence would be permitted, of course it would be.
Would the credible evidence standard in your amendment include a credible oral statement? It has to be laid out specifically under the Federal Hearth Act, and I'm just curious if you can show me where
If it's
your
credible, then the
interpretation-
answer is yes.
If it what?
If it's credible, then yes.
I don't think it's that simple, Mr. Chairman. I'm sorry, I don't mean to be abrupt about it,
But
but
I
I think
appreciate the question and the opportunity to answer it.
Mr.
Okay,
Chairman?
well, thank you. I guess I'll just conclude my comment on this amendment by asking my colleagues to not support it. I think that this does more harm than good. I think there was a agreed-upon debate in the committee around this effort to just simply remove this, and to put it back in, I think, is problematic. So I encourage my colleagues to look at this closely and hopefully vote no.
Councilmember Silverman.
Thank you, Mr. Chairman. This is the point in discussion where I will mention I'm not a lawyer. And so I need some clarity, Mr. Chairman, on, or like a point of clarification on what is credible evidence. So can you define that term for me? Because I know that at one point there was like a standard of clear and convincing evidence, or, well, okay, the constitutional lawyer next to me is disagreeing with me, but can you define what is credible evidence, Mr. Chairman?
It's about the lowest standard of proof that's available. Worthy of
What would be
belief?
considered
Worthy of belief is what
credible
I'm being
evidence
coached.
in this case?
It has to be credible.
What does
do you
that
mean?
mean, Mr. Chairman?
Well, what is beyond a reasonable doubt? It has to be beyond a reasonable doubt, or clear and convincing. Those are different levels of evidence. This is meant to be a low barrier, but it's also meant to give some flexibility to the administration.
What is your intent, Mr. Chairman? Let me ask you, because I guess I'm a little surprised by this amendment. As many people know, the council has conversation and at breakfast before the official legislative session, this bill came up, and to my memory, this amendment was not discussed. So I really am asking to vote on it, to get an understanding of, in a situation where someone presents themselves, what would be considered credible evidence, and I guess what wouldn't be considered credible evidence?
Sorry. Yeah, I thought it was funny, because there's a value to having this discussion here rather than at the breakfast, which the public doesn't get to sit and watch or get televised, so. I think I'm not sure I caught the question, because you asked what does it mean, and I tried
I'm
to
happy
explain
to ask
you.
it again, Mr. Chairman.
What's the intent?
What is considered credible evidence, and what would not be considered credible evidence?
There are different levels of evidence. I said that earlier. There's a very strict level, which is beyond a shadow of doubt. There's a the lowest would be, I think, credible evidence.
What is your intent with this amendment? What are you trying
Okay,
to
no, wait a minute. Have I
clarify?
answered that question? Because I've answered
Not
it
really.
twice.
Is it beyond a reasonable doubt?
No.
Or, okay. Okay. I actually don't understand this.
Okay. Think of a scale from 50 to 100. 50 being more than every number below that on the scale. Okay. between 50 and 100 are different levels of evidence required or proof. Credible evidence is about as close to 50 as you can get.
Mr. Chairman.
Councilmember Chey.
And your
look like
intent
you're-
with the legislation?
But this is,
Councilmember Chen.
I'm sorry, but this is not a question about a burden of proof. This is a question about evidence that's worthy of belief. So that if you, for example, are on a lease, and it looks like you're on a lease, but somebody offers credible, i.e. believable evidence that in fact you can't use that apartment for whatever reason, that's enough. It doesn't mean that I have to convince you, clear and convincing, or beyond a reasonable doubt, or even a preponderance. All I have to do is present some credible evidence that negates the fact that you're on someone's lease. It would be like admissibility of evidence in a courtroom. It doesn't mean that the admissibility of the evidence wins the day. It just means that you have produced something that's credible that we could believe, and here it is in front of you.
Does that
That's all-
answer the
that's all
question
that it
for you,
means.
Councilmember Silverman?
Well, it is truly an honor to have a constitutional scholar like
No. Don't
Councilmember
make
Chase
fun of
to the
me.
expert. No,
Don't-
I mean
don't-
that in all seriousness.
No, you don't.
I do, actually, because it is a helpful explanation, but what is really, it does get to the crux, I think, of what we're trying to address or not address with the Homeless Services Reform Act in terms of entrance into the homeless system. So, like in Councilmember Che's example, if you can present credible evidence, I'm still trying, I think the issue we have, frankly, that I hear from our Department of Human Services is that some people are taking up space in our emergency shelter system who they believe shouldn't. And I think it gets to the heart of this. I'm asking actually in all seriousness, because there is skepticism or doubt, I think, by the administration about whether these residents need, whether they're residents, whether they need that shelter or not. And I think this matter about credible evidence sort of gets to the heart of that. So I don't understand. I guess that's why I'm asking you, Mr. Chairman, about the intent here, what you're trying to accomplish by moving this amendment.
Mr. Chairman.
Well, I think my burden here is that you don't like the amendment, and you want to ask, you're hoping I'll give you an answer that will persuade you differently.
No,
And
I
don't know
honestly
that I
don't
can do that.
understand the intent.
Well, the intent is to enable the administration to deny eligibility to somebody who has safe housing. Because our shelter system, as we all know, is strained to beyond capacity. And if there are people who are in the shelter system who have alternatives, then we don't have the capacity for them. That's what this is about. And that may not be persuasive to you, but that's what this is about. That's the purpose.
Mr.
Did
Chairman.
I hear Mr. White?
Thank you, Mr. Chairman. I strongly oppose your amendment. I think that it throws off a careful balance that many of us in the committee labored to strike. This is a difficult bill that included some give and take and some things that I think everybody wasn't completely happy with, and I think this throws off that balance, and this is specifically something that we had worked on at the committee level. Your language, Mr. Chairman, adds a high level of arbitrary decision-making by the people who are going to have to enforce this. If you look at the difficulty of us on the dais defining what's the standard, clear, credible evidence, if you look at our difficulty in defining what this is, then I'm not sure how we could expect the people who are supposed to implement this for people coming in to seek homeless services could define it. And certainly you have to believe that there's going to be arbitrary decision-making. Well, it would depend on whose desk you sit down at, Mr. Chairman, and that's just not something that we can have. But to meet this standard, if it is truly as low as you say it is, and someone on a lease who shows up to avail themselves to homeless services, I think is an admission that they do not have a safe place to go. And I think that we sometimes have to take them at their word for that, Mr. Chairman. So I would actually ask that you withdraw your amendment so that we can keep the balance that we struck in the committee, Mr. Chairman. I think your amendment makes it difficult for many of us to vote in favor of this bill, and I think it doesn't recognize the sensitivity of this balance. Thank you, Mr. Chairman.
Thank you. Further discussion on this?
Mr. Chairman.
Councilmember Nadeau?
Mr. Chairman, as I said earlier, I support this amendment. I do understand that members of the committee are concerned about this. We did decide not to do this in committee, and in revisiting it, my understanding is that the administration needs some standard in place. And so what we did do is work together, you and I and the administration, to lower the legal standard from what was originally introduced to essentially the lowest possible legal standard that gives the administration a little bit of room for some interpretation. The clear and convincing standard was too high in my mind, and that was why we did not include it in the committee print. But this language that you've proposed, in my mind, is a compromise language. I understand that means there's some people who will not be able to support it, but I do hope that the majority of our colleagues will do so that we can move this bill forward and ensure that it does what is intended, which is to allow as many people who need to avail themselves of emergency homeless services to do so. Thank you.
Thank you. If there's no further discussion on this, on the amendment, all those in favor of the amendment
Can we
say...
get a roll call vote, please, Mr. Chairman?
The secretary will call the roll. Yes.
Councilmember Che?
Yes.
Councilmember Che votes yes. Councilmember Evans? Yes. Councilmember Evans votes yes. Councilmember Gray?
No.
Councilmember Gray votes no. Councilmember Grasso? Councilmember Grasso votes no. Councilmember McDuffie? Come back to Councilmember McDuffie. Are you calling 2 minutes? 2 minutes?
I already dealt with
The secretary is calling the roll, and the vote is on the amendment that I offered.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson?
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau? Councilmember Nadeau votes yes. Councilmember Silverman?
No.
Councilmember Silverman votes no. Councilmember Todd?
Yes.
Councilmember Todd votes yes. Councilmember Robert White? No. Councilmember Robert White votes no. Councilmember Trayon White?
No.
Councilmember Trayon White votes no. Councilmember Allen? Councilmember Allen votes yes. Councilmember Bonds? Councilmember Bonds votes yes. Mr. Chairman, there are 8 yeses and 5 noes.
The amendment passes. Further
Mr. Chairman.
discussion on the
Mr.
bill.
Chairman?
Mr. Grasso.
Thank you, Mr. Chairman. I want to just start out by saying how much I appreciate the work that's been gone into this legislation, both by Councilmember Nadeau and her staff in particular, also the advocacy groups that have worked hard to help educate us on the issues, and my staff as well, and all of the committee members in the Committee on Human Services. I have 2 amendments that I'd like to offer. The first one is in partnership with Councilmember Nadeau. This amendment attempts to exempt all people seeking shelter due to domestic violence, sexual assault, human trafficking, refugee status, or asylum from having to demonstrate residency. So currently the law allows the mayor to make exemptions, but it isn't mandatory or uniformly applied to every applicant in these categories. The cost of this amendment was initially estimated to be astronomical, $200 million, but obviously if that was true, then that means that the Department of Human Services has been denying a significant number of survivors from shelter for not having the appropriate documentation, which obviously would be the wrong thing to do. So if the District of Columbia is truly a human rights city, then we must protect every person who is fleeing for their lives and give them a warm and safe place to sleep at night. So I ask my colleagues to support this amendment, and I leave the remainder of my time to Councilmember Nadeau if she'd like to add to this conversation. Thank you.
Thank you, Mr. Grasso, for introducing this amendment. As you know, I had hoped to include it in the committee print, but due to the very high FIS, the prohibitively high FIS, was unable to do so at this time. There is still a FIS attached to this amendment. However, I believe we can work together between first and second reading to try to get it even lower, and hopefully work together to fund the remaining gap, because it is really important to ensure that these populations are protected under the HSRA. Thank you very much. And I accept this amendment as friendly.
Before I ask if there are any objections, let me note that if this is included, I think we need to look at second reading, whether we keep it in here. Mr. Grasso had indicated before the meeting that he was going to try again to see if the fiscal impact could be reduced.
That's correct.
Because
Mr. Chairman.
otherwise, we have a meaningless provision. If it's subject to $20.3 million or $3.5 million a year appropriation, it's means the whole provision is invalid. But we can deal with that between first and second reading. So let me ask, is there any objection to this? Then it's accepted. Further, Mr. Grasso?
Yes, Mr. Chairman, thank you. I am also going to be offering an amendment, which can be circulated now, that essentially creates a catch-all provision that would allow other documents to be considered as a demonstration of residency as long as the individual or family is living in the District of Columbia voluntarily, not temporarily, and has no intention of moving. The purpose of this amendment is to expand the list of documents necessary to prove residency so that people are not denied homeless services or shelter. And here's the background for this, in my opinion. We are doing whatever we can to narrow the door into homeless services and to widen the door out of human services, so to say. And when I've spoken to Director Zeilinger, who's been a partner in helping me understand this, one of the things that we always come back to is that we have limited resources, that the District of Columbia needs to really be careful with the money that we spend, and so therefore we should find ways to tighten up the door coming into our services. Well, that frustrates me, and I wonder if my colleagues agree, because the reality is we just gave away $36 million to a developer. We've got, project after project after project that we're giving away to developers. And I know that has a positive impact on the District of Columbia's economy, but for what purpose? Just so that we can do more of the same? I think that we need to be investing in the people. I think we need to do it meaningfully. I think there are priorities out there that should have money spent on them. I raised these concerns when I said that we shouldn't be continuing to cut taxes. And I've raised these concerns about the continual effort to put more money into days of cash on hand irresponsibly, and to be kind of beholden to the rating agencies the way we are. And I think it's time for us to wake up and spend the money where the money should be spent, which is on the people of the District of Columbia that need our services. Fortunately, though, this particular amendment doesn't have a fiscal impact. It is actually neutral. And so I'm asking my colleagues to look closely at this and allow this catch-all so that we don't have people fall through the cracks anymore, and that our safety net is, kind of mended a little and stops having so many holes in it. So moved, Mr. Chairman.
Mr. Chairman?
Discussion. Councilmember Bonds?
Yes, I have a question. When I look at number 12, any other document that the department identifies as acceptable proof of residency pursuant to rules issued under this act, I'm trying to figure out how is that different from what you're offering, Councilmember Grasso?
Well, the primary difference here is that this is the department's discretion in that particular subsection. So what I'm saying is that this catch-all is going to be documents that can be considered as demonstrations of residency, gives the department a little bit more freedom to say this person is really in a bad spot and needs us to take care of them. That's the deal here. So what we're trying to do is just clear that up a little bit more to make it a more legitimate catch-all. It's not there yet, and I've had long conversations about this, and they're afraid that this is going to open the door up for more people, and I think it doesn't. I think it just gives them a little bit more ability to be compassionate for people that are in a tough spot.
Okay, so then I have to ask, what kind of additional documents were you thinking about that would not be included in number 12?
Well, I mean, it could be something like, a letter that came to the house on their name, things like this. The problem also with number 12 is that this is, the phrase they put in there that I think is most troublesome is that it is pursuant to rules. So every time that there is a new document that might come up that is good for proof of residency, the department then has to go back through the whole rulemaking process to make that possible for them to allow that person. In the meantime, Councilmember Bonds, what's that person going to do? I mean, honestly, not allowed into the system, not be taken care of. I mean, this is the real gist here, is that it's about the not just the substance, but the process on how they can get a person through the system and into the system.
Okay, so I guess then I have to look at number 1, which is a mailing address in the district valid within the last 2 years. So if you get a document and it comes through the mail, it would therefore have this valid mailing address?
Well, that's a little bit more than just any valid mailing address, if I might say so. This is the U.S. Social Security Administration document that has your address on it. So that would be a little bit different than just any piece of mail.
Okay, well, I'm looking on the first page. Number 1 is a mailing address in the district, valid within the last 2 years. So any other kind of mail that you would receive, period, would show a mailing address, correct?
I just think that was just one example, Councilmember Bonds. I think there are other ways that people can prove residency that is beyond just a mailing address or a letter, but I think that often they have not been used and allowed to be used. Usually they require them to be a particular bill or something like that, and I think it's important to note.
Thank you.
Councilmember Nadeau.
Mr. Chairman, regarding this amendment, I just want to clarify that right now the administration does have discretion to accept things that indicate residency. This would take away that discretion, right? This is the opposite direction. I'm disappointed to see this amendment here. Again, we've had lots of conversations in committee about what the residency requirements should be and how they should be determined. There is an expansive list. We have built that list out from what was introduced. This would break it so wide open that I dare say it would be irresponsible. And so, once again, I do not accept this amendment, and I hope my colleagues will vote against it.
Further discussion on this, Councilmember Allen.
Thanks, Mr. Chair. I actually have a question to the maker of the amendment. As I look through the list of the 12 items, I do believe they're fairly broad, but I believe that the maker's intent is trying to, again, find ways to backstop. And while this may be broad, there may be examples where someone's going to fall through. The part that I'm unclear about, and maybe the maker of this amendment can help answer, the way that I'm reading this, any other document that demonstrates the individual or families living in the district, it doesn't speak to who would actually determine what is a document or, so in other words, and I think this gets to Councilmember Nadeau's point, which is it so broad that any piece of paper can all of a sudden determine what that is? And if I heard in the conversation back and forth with Mr. Grosso and Ms. Bonds, that the concern was that rulemaking could present a barrier because it's a timely issue. I guess, so I'll ask this to Mr. Grosso. Is it that the rulemaking, the concern that you have is the rulemaking creates a very long and lengthy process, which otherwise the department would say, we think this is a valid document? And in what way, and maybe this is something between first and second reading to continue working with the chair of the committee and others, is there a way to think about the language here that does provide at least something of, as determined by the department, or something that doesn't require, if your issue is the length of rulemaking, because as drafted, it makes me a little bit uncomfortable that it just makes it very difficult from a fairness perspective. How would you determine what is and isn't a document, and how could you have kind of fidelity within the system to be fair to that individual coming in seeking services? And then I also hear Ms. Nadeau's point about just opening up so broadly. Does that create a concern? So it's a long ramble there, but to Mr. Grasso, could you help answer that question?
Absolutely, Councilmember Allen. I think my amendment is intended to be fairly broad. I'll just be straight up. I mean, I think we shouldn't be narrowing the door, so it would be a true statement to say that I'm trying to expand things here. The reality is that if you put the department in there, then I think you run the risk, if the department determines what document it is, then you run the risk that they are going to not accept much of anything at all. Whereas I could see here, well, the list is pretty specific. I agree with you. I mean, it is hard to determine exactly how this would work, but the reality is that this is intended to be a catch-all for people that don't necessarily have that, envelope or the, driver's license or other way to prove it.
And just quickly, because my time is about to run out, thank you. I get that the intention is to create the catch-all. The part that gives me concern is that it doesn't define any part of it, and that just gives me a little pause, and perhaps maybe between first and second reading, those conversations can keep working.
Absolutely.
Because I do understand the intent of your amendment is to try to create that catch-all category for anyone falling through the cracks. So I guess that's just my comment, is hopefully maybe there's something we can work on between first and second
I'd be
reading.
happy to work on it.
Further on the amendment? All right, we have the amendment before us. All those in favor of the amendment say aye.
Aye.
Opposed, say no.
No.
No. The amendment fails.
Mr. Chairman, please record me as voting yes.
Further discussion on the
I have an
bill.
amendment. Chairman, this way.
Councilmember White, Councilmember Trayon White.
Thank you. First of all, I'd like to thank Chairwoman Nadeau for her and the committee and all the council members and staff that participated and contributed to this bill. Rapid Rehousing Program is a program designed to provide rental support for individuals and families that have experienced homelessness. The goal is to stabilize these families and give them some time to get on their feet to the point where they can secure and finance housing on their own. If implemented as written, families would only have 1 year before they face a hard exit from rapid rehousing. If you have paid attention in D.C. when it comes to housing, one of the most things that's been criticized is the rapid rehousing program. While we cannot provide an entire fix, this is an opportunity for us to do something about this hard exit. I do not think 1 year is enough time for a family or individual to go from showing up at a shelter to being able to foot the bill for housing at market rate when our cost of housing in D.C. is rising and rising. The Department of Human Services has continuously suggested that giving families more time to get on their feet will be financially unsustainable, but the numbers do not prove this. In the last fiscal year, the average length of stay in the program for families that exit the program from fiscal year 17 and 16 was 24 months on average. This amendment will allow for additional 6 months in the program, meaning that the longest participants will be in the program is 18 months. And this was a compromise for me, because originally I proposed the original 24 months. Today, I'm introducing an amendment that will require Human Services to create a standard to assess whether participants are ready to exit the program based on the following criteria. Number one, whether they have been assessed and referred to other housing programs. Number two, whether they have received adequate case management as a part of their participation in the program. And number three, whether they are able to sustain the housing independently. If participants does not meet the standards, they will be able to stay in rapid rehousing program for up to 6 additional months. Ward 8 residents make up the highest number of rapid rehousing participants in this job, and it's my job to protect them. Given that poverty and lack of affordable housing are the driving forces behind skyrocketing family homelessness in the district, we as policymakers must invest in solutions to actually address these issues. So I'm happy that we are looking at establishing partial rent subsidy program that we can offer to a larger number of residents. However, if implemented as written, this bill will have a dangerous impact on vulnerable residents who are receiving homeless services through rapid rehousing. When families are exiting the program, they are not ready. It is not too long that they will face eviction that makes it difficult for them to rent again. It is not too long before we see these numbers of families back into the homeless shelters again. Again, I ask for support from my colleagues on this amendment. So move.
The amendment is before us. Discussion, Mr. Gray?
Thank you very much, Mr. Chairman. I want to join with Councilmember Trayon White in recognizing a reality of what it means to be a family in shelter. I think it's a very modest request on his part to ask that we extend the time for another 6 months, up to 18 months. Because, you know, as someone who has spent time working in the homeless services area over the years, as someone who lives in a ward where homelessness is unfortunately a way of life for lots of people, I recognize quite clearly the realities of people who find themselves in circumstances that they're just not ready, as he's put it, just not ready to go on to the next stage. And then they wind up, you know, back in a situation where they're homeless once again. You know, if the issue is around financial sustainability, what's financially stable about having people go, you know, out into a situation they're not prepared for, and then wind up back in homeless circumstances once again? So I'm pleased to be able to support this amendment. I'd almost wish it was going a little bit further, and I realize that we've got to draw some financial lines somewhere along the way. But I don't think that there are many of our families, especially given the youthful nature of so many young people who are in homeless situations with their very young kids at this stage. I just don't think it's unreasonable to think that people need more time than they otherwise would get. I think the criteria that he is proposing, being assessed and being able to be referred for housing, the adequacy of case management, and whether they can sustain housing or not, that if they don't meet those criteria, then they should be given the opportunity, it seems to me, to be able to stay for another 6 months. That seems very reasonable to me, Mr. Chairman, and I'm pleased to be able to support his effort, especially since I, too, represent a ward on the east end of the District of Columbia and recognize the number of people who are populating our homeless family shelter program in the District of Columbia. While I don't have the percentages in front of me, I would dare say that the overwhelming majority are people who have lived in 7 and 8 before they became homeless. So this is an opportunity, I think, to chip away at the revolving door that we otherwise would have, and some people who otherwise would simply wind up back in a homeless situation, in fact, would have an opportunity to get on their feet and not come back into the instability of being homeless once again.
Mr. Chairman.
Councilmember Silverman?
Thank you, Mr. Chairman. I'll be supporting my Ward 8 colleagues' amendment because I believe it addresses a critical issue which explains why it is so difficult for families to permanently escape homelessness and to stabilize. The rapid rehousing program is not designed to be a catch-all system to get people out of shelter. I think everyone agrees on that. It was supposed to be a program to help stabilize people who are experiencing an unexpected financial hardship. Unfortunately, when you're experiencing a homelessness crisis and an affordability crisis at the same time, you use whatever tools you have at your disposal as a government to get people into housing, and that's what's happened here. We had a vibrant discussion about this in our breakfast. I'll note that I wasn't able to attend the hearing, but when I read the committee report, witness after witness after witness talked about rapid rehousing and how they were unable to afford, I guess for clarification for those watching, rapid rehousing is a time-limited subsidy. What this amendment would do would be to extend that time. I agree with Councilmember White that 18 months isn't probably going to help a lot of folks because a lot of these are young single parents with young children who just can't afford market rate rent in a year or even 2 years. But I think this is moving in the right direction. You know, I don't fault the administration for trying to use whatever tools are at their disposal, but I think we have to be honest, and I think we have to be clear-minded about the efficacy of these tools. We need to be able to continue serving people in the rapid rehousing program until we're sure they won't be coming back into shelter. I think what happens right now is it's a vicious cycle. People take the rapid rehousing voucher. I think from what I understand from reading the committee report, a lot of people are reluctant to take it because they know it's time limited, and then in a year they're going to be evicted. And we know from the Matthew Desmond book the devastating impact that eviction has. So I think extending the program from at least 12 to 18 months will increase the chances just a little bit. The families will have received all the services and financial assistance they need, and we can offer them to avoid another stay in our shelter. So I want to thank Councilmember White for offering this amendment. I urge my colleagues to vote in favor, and I'm happy to support it. Thank you.
Mr. Chairman.
Councilmember Robert White.
Thank you, Mr. Chairman. I just want to vocalize support for Councilmember Trayon White's amendment. I think while we do have a constraint of resources and have to recognize that we have to do something about that, we also have to recognize that we have a rapid rehousing system that is cycling many people through, and they end up back in homelessness. And as Councilmember Trayon White said, with evictions and other detrimental issues on their records. And I think that extending the amount of time gives folks who have hit, frankly, very difficult circumstances a little bit more time to get back on their feet. And if our belief is that extending the amount of time is not going to help them get back on their feet, then there should be a reminder that we need to invoke other resources, other mental health resources, job training, job placement resources. And so I think it will incentivize the city really to put people into the right programs in order to get them into permanent housing and out of rapid rehousing. And so, for that reason, I will be supporting Councilmember Trayon White's amendment, and I encourage my colleagues to do the same.
Mr. Chairman.
Mr. Grasso.
Yes, thank you. I also want to speak up in support of Councilmember Trayon White's amendment. This is an amendment that he has been working on for quite some time now, and I think has reached a good compromise so that it doesn't get too out of control at an 18-month level. And I think it's important to note that this is something that DHS will have a weigh-in on every single time that there is a situation where somebody needs to stay in for a longer period of time. And the fact of the matter is that, they claim that people are able to stay as long as they need now anyway. So it's important, I think, for us to put that in statute so that the people that are in the rapid rehousing programs recognize that they have the time they need in order to get on their feet and eventually take over a market rate unit. I met a woman the other day that has been in Tubman for 4 years, even though she has a full-time job. So there's something seriously wrong with our system, and I think that this amendment would help us towards resolving that issue. Thank you, Mr. Chairman.
Mr. Chairman. Thank you very much. I just have a question on the amendment, section B2. If the provider determines that the family satisfies the criteria established pursuant to paragraph 1 of this subsection, the provider shall be entitled to no less and no more than 6 months after the family initiative 12-month in the program. The provider, I'm a little confused. Who is the provider here that we're speaking of?
What's the question? I'm sorry.
My question is, on line 11 through 13, you make reference to if the provider determines that the family satisfies the criteria. I'm trying to, who is the provider?
The provider is whoever's providing the service to the resident.
Okay, the housing provider.
Yes, the housing provider. Yes,
Okay,
ma'am.
thank you. All right. Well, I will be supporting your amendment. I mean, the issue of housing affordability, and we all know, is very grave. And it is, in my opinion, that when we talk about housing and we talk about providing for those that are in difficulty, that we have to do everything we can to try and keep them housed as long as possible. We all know what happens with the eviction rate. We know that people find themselves, once you're evicted, you're back into the system one way or the other. And I think this gives us a little more time to work with them. So I'm very happy to support this amendment.
Mr. Chairman?
Councilmember Nadeau.
Mr. Chairman, I want to make clear that nobody here wants to see families back out on the street after they have been in our homeless services system. The key here is the right fit for each family. Now, the rapid rehousing program works for certain families. It works for more than 80% of the people who use it. And there's some evidence that if it's not working for you, the length of time is not the issue. It's that it's not the right program for you. And that's one of the reasons that this committee has invested in all the other housing programs that we have in the upcoming fiscal year. One of the main concerns that I have with this amendment is if you look at the FIS says that the Budget Office was unable to determine whether or not it would have an adverse effect on the District of Columbia's FY18 budget or the four-year budget and financial plan. Now, Councilmember Trayon White presented this same amendment at committee, and I asked him to withdraw it so that there would be time to get a more adequate FIS. As it stands, with this FIS, I do not think it is responsible to consider this amendment. That said, we are considering it, and so I urge my colleagues to vote against it. You know, this is a really difficult piece of legislation on many levels. I understand that. You know, the job of the committee chair is to do the tough stuff. And so I'm here doing the tough stuff. I understand that doesn't make me the most popular person in the room, but at some point, we have to move forward in a way that improves our system. My concern is that with this amendment, as with the other amendments, we are chipping away at a bill that moved out of committee with a compromise that allows us to stave the bleeding in a hemorrhaging homeless services system. So for those of you who are considering supporting this, I understand your compassion. I understand that. But at some point, we have to draw the line. This is a short-term program. We have other programs that we can move families into that create stability when this one isn't working. And frankly, you know, we've had a conversation about whether this program works or not. We are continuing that conversation next month in our committee. We have asked for more data, and we'll continue to drill down on that. But this amendment, as drafted, is haphazard. It's going to have a negative impact on the package as a whole. This bill is not meant to solve every problem that we have. We have a affordable housing crisis that is causing many of the other issues down the line. We cannot resolve that with this bill. So we need all the tools in the toolbox. So I urge my colleagues to vote against this amendment. Thank you, Mr. Chairman.
Chairman.
Councilman White.
We are working with the CFO on the fiscal statement. We recognize the average stay right now, and it's already 24 months. With 18 months, we're proposing that it essentially saves DC money instead of costing us more money. I think to say that we need to draw the line, this administration prides itself on being a housing administration, affordable housing. And so when we see a lot of money being spent all throughout the district on so many other things, I don't think this is the area where we need to draw the line. So to say that, it belittles the fact that we are at a place right now where we can do something about it right here, right now, with the body of people here today. And so I stand behind this. We're working with the CFO office to ensure we get the best numbers as possible, and we continue to work on this as it is now. Thank you.
Any further discussion? Councilmember Allen.
I want to ask a question if I can. Actually, I might be directing it towards the budget office. Because on the policy, I certainly appreciate where Councilmember Trayon White is coming from. Because I think we have vulnerable families that are in longer than 12 months, that need help longer than 12 months. We are having a debate, of course, between how do we and what is the most appropriate role, be it between rapid rehousing, between permanent supportive housing, between other vehicles, which I think the chair of the committee has also tried to articulate. But the part that I just don't fully understand, how is it, or what is the budget office's response, being unable to determine whether or not it has an adverse impact on the budget? Because I think I appreciate what I heard Councilmember White saying, that there's potentially a cost savings by being able to keep someone in more stable housing as opposed to returning back through the shelter system. But on the other hand, my assumption is that there's a cost with this. And so I guess I'll frame that through the chair to the budget office, if you can help maybe provide a little more light as to how we're unable to determine.
Sure, Councilmember
Thank
Allen. We did have a number this morning, but we also received some updated language this morning. And based on that updated language, it changed the estimate. And we need some time to go through. We will be able to come up with a number, but the language changed this morning. So that's the reason why we had to issue this, that says that we're unable to determine the cost.
Then I guess,
Well, if I may interrupt.
okay,
Councilmember
and
Allen?
then I want to at least save my time, though, because I have another question.
Yes, save your time. You have 1 minute and 15 seconds. Then in essence, what you're saying is that we don't have a fiscal impact statement, that you got language today that made some changes so that you can't calculate the fiscal impact.
We issued a fiscal impact statement saying that we're unable to determine whether or not it will have an impact.
But on an earlier version, there was a fiscal impact?
With earlier language,
And then you got revised language today?
yes,
And because you got revised language, you haven't been able to run the numbers?
correct.
Okay. Well, because I'm thinking that maybe we have a fiscal impact problem here, which is namely that we have a fiscal impact statement in name, but we don't have one in reality because there's a fiscal impact.
Well,
I'll
could
think
I-
about that for a minute. Mr. Allen?
Okay, thank you. What I was going to say in response to the answer is, and I guess I'll direct this to my Ward 8 colleague, I think that what I'm hearing is a lot of members who agree, at least to varying degrees, with what you're talking about and proposing, perhaps, but some degree of questioning how much does it actually cost and what would it cost to then be able to adopt a fiscal plan or put it within a fiscal plan. So I guess my question would be, since we are only at first reading, would you be amenable to thinking about basically reintroducing this at second reading once we have time to actually have the fiscal impact be a part of it? Because I think you definitely have sympathies up on the dais in terms of folks trying to think through, which would also give the time to continue working with the chair of the committee.
As stated, thank you, Councilmember Allen. As stated, we are going to continue to work with the CFO office, but we're going to put it on the table today and take a vote today and get a roll call on it and move forward with it.
Okay, fair enough. Just wanted to ask.
And point of order, Mr. Chairman.
Yes, Mr. Grasso.
Through you to the budget office, this fiscal impact does satisfy the rules of procedure moving forward, correct? We can have a vote on this, correct? Or else why would you have issued it? I'm asking the budget office, Mr. Chairman.
Yeah, I know, but the interpretation of the rules is in the discretion of the chair. And I haven't decided yet.
Well, I would just make a point, Mr. Chairman, that I believe it does. I think that it's important for us to move forward on this vote today. And knowing that we might get something more developed moving forward, that's fair. But we've voted in the past with fiscal impacts of this nature, and that should not preclude us at this point from voting today.
Let me engage you in conversation for a moment, because I'm trying to figure out what to do. What the budget director has said is that a previous version of this had a fiscal impact, that the language was changed, but that the office, because they got the revised language today, they've not been able to do calculations. So what they did was they issued a statement saying we've not been able to calculate the fiscal impact.
Well, I would just say in response to that, they actually issued a fiscal impact statement saying that they are still working, but that is something we've done in the past where we knew that this was going to move forward. We just knew that we needed a little more time, but we were allowed to proceed forward to a vote on this exact language that we have here. And so I would just ask that we just not all of a sudden change that approach today, given the past precedent, so that we can have a vote on Councilmember White's amendment, which I think is a very important amendment that we should have a debate on in the first reading of this bill. And then if it blows up and there's something in the second reading, we can always change it. But this is, I think, complies with the rules. And I would ask the budget director what her thoughts are on this, because I think it does comply with the rules, because she's said it before.
Well, the definition of fiscal impact, Rule 309 requires a fiscal impact statement. And the definition, I want all the members to hear this, means a statement prepared by the chief financial officer or the budget director that includes an estimate of the costs that will be incurred by the district as a result of the enactment of a measure in the current and each of the first 4 fiscal years for which the measure is in effect, together with a statement of the basis for such estimate. Now, the budget director has said that she's been unable to, given the time that she had, has been unable to issue a statement of the basis for the estimate of the costs that will be incurred. And I'm reading the language here, that includes an estimate of the costs that will be incurred by the district as a result of the enactment of the measure in each of the first 4 fiscal years, together with a statement of the basis for such estimate. I think it's reasonable to say we don't have that.
Well, Mr. Chairman, I would ask then, do we need to go back and look at those other provisions that we allowed to move forward and determine whether or not they were legitimately voted on then, if that's the rule we're going to play with now? Because the fact is that I don't understand why we would have done that in the past if we're not willing to do it today for the Ward 8 representative.
Well, I don't recall the last time we had a fiscal impact statement that said unable to determine the costs.
But let's ask the budget director if she can speak. She can probably tell us
that's
whether or
what
not
we're
this
waiting for.
happened before.
Well, are you able to give us, what? Are you able to
Madam
give us
Budget
an
Director?
estimate of the costs?
We will. I cannot at this present time.
But have you ever done this type of fiscal impact before? And do you recall whether or not it was sufficient to move forward with a vote?
We have done FISs like this before, on an interim basis.
Right.
Working towards an actual number.
And was it sufficient for a vote? I believe it was,
I don't know how she can answer that question.
because it's just a memory question. We're both trying to remember, and she might remember because it's her job to issue FISs, and she probably remembers.
Mr. Grasso, let me be clear about something. The interpretation of the rules is solely within the purview of the chair of the council, solely. And if you don't like an opinion of a ruling of the chair, you can appeal the decision. And in
Chairman.
that way, the full body has a measure of influence on what the decision is. The issue, as far as I'm concerned, is that regardless of what you think about this amendment, this happens from time to time. And we have to take seriously what the fiscal impact requirements are, because there'll be another measure in which I can come up with a fiscal impact, and I can come up with a fiscal impact statement that says unable to determine the calculation. And you're not going to like that. So we have to be reasonable here.
I
Now,
agree
I'm
with
also
you.
mindful of the
But
fact
we've done
that
it.
we're
That's my
halfway
point.
through the debate on this, and half the members of the council have spoken. And so half of the members of the council will be unhappy if I rule this out of order. So I have to be mindful of that as well. But this is very serious. That is, we can't play games with what the fiscal impact statement says.
Mr. Chairman, I agree with you entirely. What I'm saying is that we already did once before. So now to choose that we're not going to do it, this is my point. It seems like an inopportune time to do
Chairman.
this.
Trayon White.
As maker of this amendment, I would like to speak on it. I think that if we've done it before, I think we should do it now. I think there's a lot of debate on what it should be. I think that I'm confident in the CFO office that we can present something soon. They gave us some confidence in that we will have it. And I think we should push forward. If it doesn't pan out, we can always come back and revisit it at some point. And so we should move forward.
If there's no further discussion, all those in favor say aye.
Aye.
Opposed, say no.
Can we get a roll call,
No.
Mr. Chairman?
Roll call.
Secretary will call the roll.
Councilmember Evans? No. Councilmember Evans votes no. Councilmember Gray?
Yes.
Councilmember Gray votes yes. Councilmember Grasso?
Yes.
Councilmember Grasso votes yes. Councilmember McDuffie?
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson?
No.
Chairman Mendelson votes no. Councilmember Nadeau?
No.
Councilmember Nadeau votes no. Councilmember Silverman?
Yes.
Councilmember Silverman votes yes. Councilmember Todd?
No.
Councilmember Todd votes no. Councilmember Robert White? Yes. Councilmember Robert White votes yes. Councilmember Trayon White?
Yes.
Councilmember Trayon White votes yes. Councilmember Allen? Councilmember Allen votes no. Councilmember Bonds?
I've been asked to vote no.
What does that mean?
No.
Councilmember Bonds votes no. Councilmember Che?
No.
Councilmember Che votes no. Mr. Chairman, there are 6 yeses and 7 nos.
The amendment fails. Further amendments on the bill? All right, we have the bill as amended before us. All those in favor, say aye. Aye.
Mr. Chairman, can we get a roll call on the bill?
On the bill, the secretary will call the roll. The vote is on the bill.
Councilmember Gray? Councilmember Gray votes yes. Councilmember Grasso?
No.
Councilmember Grasso votes no. Councilmember McDuffie?
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson?
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau? Councilmember Nadeau votes yes. Councilmember Silverman?
Going to vote yes, Mr. Chairman.
Councilmember Silverman votes yes. Councilmember Todd?
Yes.
Councilmember Todd votes yes. Councilmember Robert White? Yes. Councilmember Robert White votes yes. Councilmember Trayon White?
No.
Councilmember Trayon White votes no. Councilmember Allen?
Yes.
Councilmember Allen votes yes. Councilmember Bonds?
Yes.
Councilmember Bonds votes yes. Councilmember Che?
Yes.
Councilmember Che votes yes. Councilmember Evans? Councilmember Evans votes yes. Mr. Chairman, the vote is 11 yeses and 2 nos.
The measure passes.